Hello and welcome to Mullens Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by my colleague, Claire Pollock, a paralegal in our employee benefits and executive compensation practice, to discuss the restatement of 401k plans, prototype pre-approved 401k plans. Thank you, Claire, for coming on to the Benefits Companion.
Thank you, Brydon. I'm happy to be here.
Claire is instrumental in making sure our clients' documents are in order and working with clients who have pre-approved plan documents. So I thought it'd be really helpful to the listeners to hear some of Claire's thoughts. Claire, the listeners are probably familiar with the concepts, or they've heard the terms individually designed plans and pre-approved plans. What are the differences between those two types of 401k plans?
Sure. Retirement plans have to be maintained pursuant to a written plan document. A written plan document can come basically in two forms. One, like you said, is an individually designed plan, which, as the name implies, is designed and written specifically for that employer. All the terms of the plan are written in their plan document, your eligibility and your description of your who's participating in your plan, your contributions, and so on, are written into that employer's plan document. The other alternative is a pre-approved or prototype. We're using the word pre-approved more now. We've sort of phased out the term prototype. That document is going to be maintained by what we'll call a document provider, which could be a bank or another financial institution or a law firm or a third-party record keeper. That plan document is going to consist of two pieces. One is a base plan document that is all of the boilerplate language, the definitions, the terms that don't have any flexibility in your plan document. The second component of that plan is an adoption agreement, which is the check-the-box document that an employer completes to describe all of those terms that I just talked about. Your eligible group of employees, your entry dates, your contributions, your allocations, your distributions, all of those rules are going to be in an adoption agreement prepared by your document provider. Those two documents are part of your plan document. The IRS is requiring the pre-approved plans to be updated periodically to incorporate changes in law, new regulations, and so on a 6-year cycle. So we are in right now the middle of a 6-year cycle, reapproval process for the 6-year cycle for defined contribution retirement plans.
So that's why a lot of clients and employers may be receiving documents from their document provider. If they've adopted their adoption agreement, they've had this plan in place for 6 years or more, and now they're getting a new document from their provider. And so is that because of the 6-year cycle?
That's exactly right. And this program has been going on for long enough that we're now in the third 6-year cycle. So when our employers are hearing from their document providers, they might get something that says it's a third cycle restatement or a cycle 3 restatement, which doesn't necessarily make a lot of sense to the employer unless they knew why we're calling them the third cycle restatements. Right. So the document providers are sending these new adoption agreements to the employers and saying, review these and sign off on them, please. It's so important that this review be done very carefully by the employers.
Right. So when you get one of these documents, you shouldn't just say, okay, and sign it and send it back or put it in your file. It's when these arrive, what are really the first things that an employer should do when they receive a new pre-approved plan document?
What we suggest, or if we're asked to help in that regard, we literally just do a side-by-side comparison. We take our old one, we look at our new one. Is everything completed the same? Is everything reflected the same way, from eligibility to contribution types to allocation formulas to distribution options? Sometimes these documents might have been regenerated just by a computer. You might have a system that pulls from the old and creates a new document, or it might be done by a person who has then generated your new document on the system. So there is a potential for error. Errors in a new adoption agreement can be problematic.
Right, because the plan document has the force of law. You are required to maintain the plan's tax qualification status to administer the plan in accordance with its terms. And when an employer executes a new adoption agreement, that's an amendment and restatement of your plan. So if there are changes in the adoption agreement that you don't know about, that's a problem, because you might, you're still going to administer the plan the way you think the plan reads, but you receive this restatement, this cycle 3 restatement, and inadvertently there was a change in the adoption agreement, and the plan document now has diverged from the way the plan is intended to be administered. And I've seen this not only with these types of restatements, but if an employer changes its plan document provider or goes to another financial institution and adopts a new adoption agreement, errors have happened where the definition of compensation, a different box has been checked for what plan compensation means. There's one situation where the plan's automatic enrollment provisions were checked in the adoption agreement, and the client had no intention of providing for automatic enrollment. Well, if the plan document says that new employees are automatically enrolled and you're not doing that, that's an operational failure to comply with the terms of the plan. I saw one situation where an employer's adoption agreement had safe harbor contributions checked, and they were still testing for ADP and ACP testing. They had no intention of having a safe harbor plan, but the adoption agreement had a mistake and had safe harbor elections. So that's why, and Claire is great at this, that we review the two adoption agreements very carefully side by side to make sure that there isn't an inadvertent change to the plan's terms.
So when you see those differences, you go back to your document provider and they can correct it. It's not that the document that they sent you to sign off on is the final word. We can make those changes. The IRS has set a deadline of July 31st of 2022 by which employers must adopt these restated adoption agreements. Seems like a long way off, but I think document providers are trying to send these maybe in batches to their employers, because some of them may have, a couple thousand documents or adoption agreements or plan documents that they need to get signed off on. It helps us understand why people are hearing about it right now, but they do have time to make corrections.
Right. But and they need some time to review the documents, and then if there's a correction needed, make the correction.
Yeah. Now, if a mistake has happened, or even in the review process, while the employer is looking at its old adoption agreement and finds something and says, we never noticed this before. We haven't been administering our plan this way for 2 or 3 years. Employers do have options to make corrections.
Right. I mean, there's the IRS has a correction procedure that actually the new EPCRS Rev Proc was issued recently. And so it's important to catch those errors, especially operational errors, sooner than later. And if that's discovered, they shouldn't be swept under the rug. They need to be addressed. And there's an IRS correction procedure to protect the plan's tax qualified status. And there's no limitations period on a plan being disqualified. So if there was a qualification error where the plan was not administered in accordance with its terms 5 years ago, that the plan remains in jeopardy until that error is corrected.
So I wanted to point out a couple other things too. What we're talking about right now is this third cycle restatement is only applying to 401A defined contribution plans, which are profit sharing plans, 401k plans, money purchase plans. It doesn't apply to 403B plans that are maintained by a tax-exempt entity or a school. They're on a different cycle. Those pre-approved 403B plans were just re-upped in 2020, and so they will have another cycle that will be 4 or 5 years hence. Pre-approved defined benefit plans are also on a different cycle. They will have to be restated by January 31st of 2025. So that's a little bit further down the road. So we're just talking about garden variety 401A retirement plans right now. It's also important to note that these restatements do not include a couple pieces of recent legislation because of the timing when the document providers had to submit their plans to the IRS for approval. It does not pick up a couple of recent pieces of legislation. For instance, Bipartisan Budget Act of 2018 contains some changes to hardship distributions. Those changes must be adopted for calendar year plans by the end of December of this year, December 31st of 2021. Your document provider may send that as a standalone amendment, or it might be coming with these third cycle restatements. In addition, at the end of 2019, Congress passed and the President signed the Secure Act, which made a couple changes to retirement plans. Then right after that, in March of 2020, Congress passed and the President signed the CARES Act, which also has some optional changes to retirement plans. Those amendments will need to be adopted by a calendar year plan by December 31st of 2022. So those amendments also will be standalone amendments that employers will be receiving from their document providers. That deadline, that December 31st of 2021 for hardship distributions and for December 31st of 22 for the Secure Act and the CARES Act will also apply to amendments to those individually designed plans that we talked about a little while ago. So all employers can be expecting to be amending their plans this year and next year for hardship distributions and for Secure Act changes. Governmental plans have even longer deadlines. For instance, for the Secure Act and the CARES Act, governmental plans don't even have to be amended till 2024. Seems out of sync based on when all of these provisions have been effective, but that is just the extended deadlines that the IRS gives employers.
Well, Claire, thank you so much for coming on to the Benefits Companion. That'll wrap up our discussion. If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.